The Bayelsa matter, remember INEC, political parties, elections are forthcoming, so the argument just going back and forth. Who's been disqualified, who's not, will the elections hold, when will they hold? Mr. Father Agbaje joins us now. He's a legal practitioner. Thank you for coming this morning.
Thank you for having me on your wonderful program.
Thank you. Well, some major development as it is now. Of course, you know how lawyers would do. There's always two sides of the coin, they say. You have those who will say, no, INEC is correct, others think otherwise. But now that INEC has released the list of candidates to contest this election, there's this caveat about the People's Democratic Party. Now, some on the part of PDP think INEC, in fact, they say INEC has excluded them from that. But INEC indicated, well, this is subject to litigation. Put it in perspective for us, if you will. What's going on?
You see, INEC hasn't got my sympathy. I have to be very blunt with you. As far as I'm concerned, INEC has just succeeded in shying away from its statutory constitutional responsibility to the people of this country in respect of Bayelsa State.
How?
You see, I wonder under what provisions of this electoral act, because I have gone through it now and then. Under what section of it is INEC empowered to say we are not going to accept a particular candidate or a particular political party because there are litigations in court? What is the present statute? What is the present state? Even if there are litigations in court. What is the position as of today? This was a case in which somebody has already been picked by a political party. His name was on the list. All of a sudden, another primary was put in place. And the man said, look, the way things are going, I might be to change of my right to carry the flag of this political party. The man ran to court, which is the most ideal thing. Instead of going to the street or calling out his supporters, the man chose the best civilized method, going to court and say, well, look, let me go to the court and assert my right. Let the court decide whether what my political party is doing is in conformity with the law or not. That was the case, irrespective of whether even that court has jurisdiction as at that time. Because one of the provisions of the Electoral Act, Section 87, 11, say, look, no court can issue injunction. We have our reservations on that provision. We have always said it, that provision is an affront to the inherent powers of the court. Okay. As a court of record, it can issue, if a court can make declaration, it can also issue an injunction. So the issue of whether the court can stop it or not is not belated. That has always been our argument, that the court has that power to do so. And that section 87, subsection 11 is a mere nullity. And I'm happy that when the case eventually got to court, the court made another of injunction. Although the court went further to say, to threaten the PDP as certain things and consequences that will follow. There was an appeal to the Court of Appeal. And the Court of Appeal looked into the matter and said, okay, fine. As far as we are concerned, the lower court has jurisdiction, which was the major platform on which an appeal was lodged. But the Court of Appeal now went further to say, well, in view of the pronouncement by the judge threatening that if PDP as a party does not come at the next adjournment, they should be ready to face the consequences. On that pronouncement alone, then the Court of Appeal now said, we are making an order for the transfer of that case to be heard by another judge. But meanwhile, the good news is that that court has jurisdiction to make the earlier order.
So that matter will proceed.
Yes, that matter will proceed. Meaning that, irrespective of the Court of Appeal, the position of the Court of Appeal, the order made by the lower court was never vacated. So it's still extant. So to whom does that order that subsists endure? Is it the PDP or Silva? With due respect, it's to Silva. Okay, so until that order is vacated, it is a misconception of the law to say because there's a case in court you are not going to. When already there's an existing order yet to be vacated.
So what
you cannot. So my position is that
what should INEC have done?
What INEC should have done was where Silva has to carry the platform until the litigation is determined. Because, mind you, the law does not allow for a vacuum. And more also when there is a subsisting order yet to be vacated. So until that order is vacated, what the INEC court have done is, Silva, you continue to carry the platform because you have an order to your favor. That order is subsisting. they did not allow that because, for whatever reasons, the INEC say, look, there's a case in court.
Okay.
It is not right.
You've established.
In other words, irrespective of the position of the existing injunction, INEC says they are not
okay, but
they are not bothered about it.
For those who don't understand, since you've established that the matters are in court, that they've not been dispensed with.
Yes.
Could you then interpret for us the doctrine of least pendants, where they say nothing new must be introduced? Because if INEC goes ahead and puts the incumbent governor's name, hasn't INEC introduced?
No. It has
haven't they granted the prayers which they are seeking to clarify by the court? If
No.
Somebody's name there?
No. That is not the essence of least pending. The essence of least pending is that once the matter is in court, nothing to change. In other words, you cannot now come and add to it or attempt to make or take some step that will overreach the subtractum, that is the very substance of the pending case. That is not what has happened here. What INEC would have done is to play safe and say, well, there is a case in court, another has already been granted, ex parte, like the labor case we went to. I just came back. Another was granted, rightly or wrongly. The other was even enforced against people like me.
So what is the substance in this case?
The substance in the case is that INEC, the PDP should not continue, should not go ahead with the conduct of the primary. And that even if you are going to go ahead to conduct the primary, I am the authentic candidate that has earlier been nominated. And that was the position until the court decided, granted him. Of course, otherwise the court would not have granted that ex parte injunction. There were material that were placed before the court, and one of the material placed before the court is that this is a man that has a name, was already been asked to carry the flag of that party. It was on the basis of that, the court would not have manufactured facts and based an ex parte. Ex parte is a very serious injunction, particularly when you have not had the other side. The court look at the fact before it and say, look, you can't do this in law. You have already nominated somebody to carry a flag. What has it done? And don't forget the fact that even under section 85 of the electoral act itself, within 21 days, you are expected to submit the list of a candidate.
Okay, but you're going to say something?
Yeah, I was, thinking that, if the court has said that the PDP shouldn't have gone ahead with that particular primaries, and they went ahead.
Yes.
And they're not taking the candidate. I mean, INEC is not taking the candidate now.
Yes. But
before this time, they had already done some primary in January 2010.
Yes.
And they went ahead. Silva emerged as the candidate, for flag bearer for the party. Now that it seems INEC is also saying that they're not accepting that as well, because it seems that with the elections being postponed, it's like that was already null and void. So it's like INEC itself is in a dilemma.
INEC deliberately created that dilemma for itself. When you look at the functions of INEC under the Electoral Act, is to monitor and ensure that there's compliance with the law. That is all the responsibility that was given to INEC. But you discover that INEC, in the course of executing its statutory function, it has now added to it. Whatever confusion exists on the ground now is as a result or the product of INEC myopic interpretation of the clear provisions of the Electoral Act. The power it doesn't have, it has arrogated it to itself. So what INEC has succeeded in doing now is to prepare the ground. I regret to say, is to prepare the ground for the challenge of whoever emerges from any of the existing political parties at the end of the day. Because when you look at Section 138 of the Electoral Act, one of the grounds in which you can challenge election is that, well, look, I was rightly nominated to carry the flag, but I was unlawfully excluded.
Mr. Agbaje, a moment here. Let's quickly see, to project and see if we can actually get something out of the future now, legally speaking as well. Is there any comparison to what, or similarity rather, to what happened in River State and the case?
I was going to go into that later, that what INEC has done is to prepare ground for a re-emergence, for a reenactment of the ugly.
Because sorry, we say this. Sorry,
what happened in River, where somebody who never campaigned for election, my good friend Governor Ritimi Amici, never campaigned, and at the end of the Supreme Court look at the fact of the case and look, this man was rightly nominated but unlawfully excluded. What are you talking about? Is that the essence of the rule of law? Go and swear him in. I hope we are not marching towards
because
that.
Actually yesterday
because even at the end of the day, even if at the end of the day, the elections to go ahead with the exclusion of a man who has a mandate on his hand, and he also have an ex parte injunction kneeling in his favor. These are facts the Supreme Court ultimately will have to consider and say, look, what are we talking about here? Why did INEC not at least save his face and say, well, in view of the existing order, this is the man to carry it. But if the court in the next 1 week hears the case and decide otherwise, that is the end of the matter.
Because
so the INEC would have perfectly had a legal ground to stand. But the way it is now, I laugh at INEC.
Are you saying...
Is it INEC you laugh at or the PDP? Because yesterday actually brainstorming outside the studio, it was even Markwe who was actually bringing this to the fore, looking at it critically now. Maybe they go to the elections and people cast their votes for PDP, ultimately maybe with no candidates, if it's not resolved.
Yes.
And PDP finally wins with no candidate as the flag bearer for that particular election.
Yes.
Do you go ahead and declare the party the winner that has fielded no candidates?
It's not the fault of the candidate. For instance, I'm not holding brief for Silva, but I'm just analyzing what the law is. The man will get up and tell you, Mr. Silva will get up and say, look, I didn't disqualify myself. I didn't exclude myself.
So
I am ready. In fact, I have been saying it from the word code that I am the authentic candidate to carry the flag. You discover that having regards to what has happened in the River State as a case study, as a judicial precedent now, I can't see how the PDP and ANEC can escape the legal consequences of their action.
Are you saying then that it's a possible scenario that the PDP can actually go into the elections without a candidate?
As at now, having regards to what has happened in the court, both the Federal High Court and the Court of Appeal, there is a candidate.
Okay, but if you say there's a candidate, the governor is in court today because he says the process for nomination or selection of a candidate for a party has not been duly complied with. That's part of the reason why he's in court.
Yes.
And so if he's in court for that reason, how then can INEC go ahead and put his name there as the candidate of the party? Because also remember that the law says it is the political party that presents a candidate.
Exactly.
A candidate does not sponsor himself or herself, since you don't have that independent clause yet. Because if he goes ahead and says, I am the the candidate for this party, would I not be saying I'm the one who has to sponsor myself or impose myself on the party? Because if you're in court saying this process has not been complied with, and INEC says we haven't disqualified PDP, we saw that in the papers, they're saying, listen, it's subject to litigation, not referring to the political parties, referring to them as an individual. So whoever eventually emerges from that party gets allocated to the symbol.
Who has created the logjam?
Is it a logjam now? Because INEC doesn't see it as such. He says the logo is there, meaning the party has not been disqualified.
The party has not, but it must produce a candidate, like you rightly said.
They have to.
And we are saying, look, having regards to the antecedent of this case that has happened in Bayelsa State, here's a candidate. We cannot.
Based on
what is the essence of going to? Okay, what is the essence of going to?
He is going to court. As I just highlighted, he went to court saying, of course, if they take you to court, you have to defend yourself.
Exactly.
So he says, look, this process has not been complied with.
Exactly.
I've been provisionally cleared.
Exactly.
And so having provisionally cleared, you cannot exclude me from another primaries. But the party says, well, we've got a procedure here. You scaled the first hurdle. You haven't scaled the ultimate one, which you are well aware of, which happened the first time. And so they say not.
You see, what has happened? Let me take your argument.
Please do.
As you have related it. The question is this. Has PDP itself not agreed that there was an initial primary that produced the present governor of that state?
Was it conclusive?
You said it was inconclusive. That was one of the issues.
No, from legal perspective, was it conclusive, given the processes that you had to go through to finally emerge as the candidate of the party?
What has the PDP been doing all along when the man has been parading himself as, look, as far as I'm concerned, I have your certificate. This is the same thing, almost the same fact with what has happened in Izuna versus Uzodima's case, which eventually got to Supreme Court.
The Senate.
A man was given a certificate of return by the party. Just because a colleague of mine wrote a petition against that candidate and said, look, this man has a case pending against him in the US. And INEC, quote unquote, again.
And those two different cases, because if you were given certificate of return.
Where I'm going is this. Where I'm going is this.
Okay.
The issue that arose in that case was that INEC justified to have excluded or withdrawn that certificate?
In that circumstance?
In that circumstances.
What do you think?
What the Supreme Court said, look, the man, as far as the Supreme Court was concerned, and having regard to the fact of the case, the man was duly cleared and he had gone through the hurdle and he must be given the certificate. That's why the man is there. But I'm happy that the Supreme Court even went for that to say, look, if the process, because my colleague had come here and said, well, having regard to the case of Onoha versus Okafor, once a party has decided on the candidate, that is the finality. But that's no longer the situation under the amended Electoral Act. The mischief which existed under the earlier Electoral Act, which precipitated or led to the Okafor's case, which had become the platform for corruption in the primaries these days, where a godfather will get up and say, well, this is my anointed candidate, all the members should stretch hand and bless such a candidate. It's no longer the situation here under the new Electoral Act. If there is a violation of any of the provisions of the Electoral Act, as well as the guidelines under the constitution of the party, under section 87 now, you cannot go to court and challenge it, and that's what exactly
Mr. Agbaje, so
Silva is doing. He cannot challenge it. So those who are saying we are branding the principle of a Okafor, just look at them and laugh. The international case, the Supreme Court said, look, once you can establish that there is a violation of the process, the court will look at it and they remedy it.
Mr. Agbaje, so you're saying now that as it stands, Governor Silva is the candidate or should be the candidate of the PDP, based on what?
If I were the legal advisor, that would have done told them.
Based on which primaries?
Based on the other primaries.
That's the January primary.
You cannot have two primaries. I have never seen anywhere in the Electoral Act where it's provided for that there must be two primaries.
For which he has a provisional clearance, because in the Zunaso case you mentioned, it was conclusive. But in this case, the party says you have not fulfilled all the requirements.
Then the party would have gone to court again, just as he has done. No, if you think I'm wrongly or illegally flying your card, your flag, you can go to court. That's what the Electoral Act is.
It wasn't conclusive.
That's why it was conclusive.
How could the party have gone to court when they say, well, we are the ones organizing this?
You've forgotten the clear provisions of the evidence that he who alleges must prove.
Yeah, but the party had not alleged anything. It was the governor that went to court. So the party had to defend themselves. So the party says, we've got our provisions here internally.
Why would the party not go and face the consequences of that case in court?
Well, anyway,
because the party let me tell you what that party was essentially doing. They were relying on the clear provision of 87.
Which says no court.
11, no court can grant it. That was on the premises. They sat on the fence.
Rightly or wrongly.
Rightly or wrongly. And then the Court of Appeal. I have said it here before, earlier.
But can that be thrown out?
Yeah,
isn't that strong?
It's unconstitutional. It does not deprive a competent court of record from looking at the grievances that the man has brought to court. Don't also forget that it was under section 87(10). You see, an aggrieved party who feels that the process has not been followed can go to court. It has now become a statutory right for you.
Could you explain this section 83 of the Electoral Act? It talks about allocation of symbols, because it says here, where a symbol is registered by a political party, in accordance with this act, the commission shall allot the symbol to any candidate sponsored by the political party at any election. Now, INEC in their case says the logo of the party is there. Always, why we say this is subject to litigation is because we cannot put a name there. Until the court dispenses with this case, your candidate, his name is attached to the symbol as provided for in this Electoral Act.
I'm telling you now that is the more reason why INEC could have played safe. If it has gone ahead now to put the party symbol there and said, well, we are not attaching any candidate name, does that make sense?
According to this act,
does that make sense? We must also look at, we don't just look at the provisions of the law, we must also look at the intent of that law, the spirit behind that law. Does it make any sense?
Mr. Agbaje, is it possible that INEC can put the name of a candidate which the party has not presented?
Is it in front of the candidate?
No, but is it possible?
Legally speaking, is it?
You are saying that INEC has INEC has taken upon itself, has arrogated new powers to itself by not by not putting any name there as well, by refusing to accept certain names as well. But is it possible
is INEC not
for INEC
is INEC not even now sitting over, as I mean, now is it not sitting over as a super or superior court in the land over the decision of the Court of Appeal? Why would the Court of Appeal not say, oh, that ex parte order ought not to have been granted?
But INEC cannot accept a name that hasn't been presented by a political party.
The man did not,
isn't that new powers it's going to be abrogating to itself?
The man did not fall from the sky and say he has never even proclaimed himself to come from any other party except PDP. As far as it's concerned, as far as the law is concerned today, the man remains the PDP.
But you just tell us the implication of all of this. Today is the 18th of January, and the elections comes up, I think, 11th of February.
And under Section 85 of the Electoral Act, it's not later than 21 days. You must submit. So they have the problem of Section 85, 86, and 87 on their hand to sort out too.
Is it INEC that has that problem? Sorry, Sulaiman. Is it INEC that has that problem with the PDP?
Both of them, as far as I'm concerned. Both of them.
So if you were to advise the PDP now, knowing full well that elections is 11th February, and we're looking at that particular section of the Constitution,
I regret to say this, but I think what some people are just working towards is that if we cannot have it for a candidate, then let the whole thing go. And it's not fair. It's not going to be fair. Because what is the essence of justice? It's only in this country I see that a man loses an appeal and is celebrating it. And as if it is now a constitutional right that you have lost an appeal and then you should be applauded. I was thinking that the matter should not have ended there. They still had the opportunity of testing it at the appeal court and say, that order, was it validly or wrongly made? As far as there was no appeal, further appeal against it, and they are back to the Federal High Court, that order must.
Okay, but just reiterate for those who may have just joined us, because I mean, reason they say it's the soul of the law.
Yes.
If the political party says we are, I mean, even according to the law,
yes,
we are the ones who will present a candidate to INEC. INEC cannot choose who we have not presented, and then the incumbent governor goes to court saying, well, the procedure for selecting a candidate has not been duly complied with.
And that he still remains.
Right. And that matter, he still remains. And
what you are going to do with the next person is not in compliance.
And that matter has not been dispensed with in court. And INEC say in compliance
it's not been dispensed with, but don't forget that there is in existence. That's the point I'm still emphasizing. It's not been dispensed with. There is in existence an order, which is the ex parte injunction. Don't do this.
No, but
you come back, you come to me.
The PDP said they complied with that order because they did not disregard it, in the sense that they filed a reason why he is not the candidate, and that's why the matter is proceeding.
That issue is yet to be determined. Whatever
So
PDP, let me tell you one thing. You see, the way things are now, Silva against PDP, are they on the same legal footing today?
Are they?
They are not.
Why?
There is an ex parte injunction that turns to somebody's favor. The other party hasn't got anything. How can you say we are on the same level? If we are on the same level, what the simple question is, why did PDP rush to the Court of Appeal? They would have just sat there. We can't just sit down here and begin. The law has gone beyond that.
Give us a scenario. Sorry. What happens if INEC puts the name of the incumbent governor against the symbol of the party in the ballot, and then the party says, wait a minute, INEC, we are the ones to choose a candidate. We have not submitted his name. What happens?
It is too late for them to say that.
Really?
It's too late.
So
because what INEC would have done is, look, please, Mr. PDP or whatever you call yourself, this is the position of the law. Go and challenge that order. Now that the Court of Appeal has said that court has jurisdiction to do what it did, and the Court of Appeal did not back that order, because that was the premise. One of the premises they went to Court of Appeal. Oh, the court has no jurisdiction. And to us lawyers, once the court lacks jurisdiction to hear a case, whatever consequential order is given, it's a nullity. It goes to no issue. But the Court of Appeal is telling you that man who gave that order, that court, they have jurisdiction to do what he did.
Well, don't you just think...
What do you have to say to this, Marcus, about the insistence of the party saying that Section 31(1) of the Electoral Act, actually took off the powers of INEC from rejecting or disqualifying the candidate submitted?
Yeah, that is true. That is pretty part of the law.
Good.
And that's why I was telling you when
that means that the PDP and INEC in this case, well, are you saying they're both on the wrong path?
That is the clear implication. That's what I'll be saying. That if I were the legal advisor to INEC, of course, Mr. INEC, this is your position. As of today, that's why I asked the question. Are the parties on the same level as of today? They cannot.
Mr. Agbaje, can I?
It will amount to defeating the cause of justice. You might not like this party or that, like I have done some time ago, but the law says it has to be obeyed.
Okay, do you see a scenario whereby it would just be safest for INEC to just put the party logo and whichever candidate? Do you see that kind of scenario happening where the PDP's logo is not even on the ballot paper?
I have told you that the PDP, the INEC has already prepared a fertile ground for any election in that state to be challenged in future. I foresee a situation that some party, or one party will say, look, if I can't have it, the all of us will lose it, and it's not right.